Hey, dear audience, what is landlord-tenant rights for disabled tenants?
In California, landlords must provide reasonable accommodations for disabled tenants at their own expense. Accommodations can include adjusting rules, procedures, or services, providing a close-in, spacious parking space, allowing home modifications that are reasonable and do not harm the property. Some conditions that qualify for disabled renters' rights include mobility, hearing, vision, severe mental health conditions such as anxiety, depression, and PTSD, HIV, AIDS, developmental disabilities. For example, landlords renting buildings built after March 13, 1991, with more than 4 units and at least 1 elevator must provide reasonable accommodations and modifications for individuals with disabilities. Landlords are not allowed to ask applicants about a disability or illness or ask to see medical records. Assistance animals must be allowed with proper documentation.
Can a landlord evict a disabled person in California?
If a tenant fails to pay rent, they can be evicted, even if they have a disability. It's essential for tenants to understand that while the law offers protection against discrimination for mental disability, it does not excuse non-payment of rent. Landlords can and will initiate eviction proceedings for unpaid rent. What are my rights as a disabled person in California? All California retail establishments, restaurants, hospitals, hotels, and other public places and transportation must offer people with disabilities the same service and facilities as the general public. This includes acceptance of service animals. People with disabilities are also protected when they seek housing. If you have a disability, you have certain rights as a tenant, which are guaranteed by California's Fair Employment and Housing Act FEHA, as well as the Federal Americans with Disabilities Act. Call now, 714-442-9741. Thank you. For more detailed information, please refer to the comprehensive summary provided in the description section below.